there's one case. There may be one more case. There's a.
Give this to Kimberly. Tell her to get rid of it.
Yeah, I'm off this.
Thank you.
Thank you.
Good morning, Mr. Firstenberger. As you know, you have 10 minutes, and the light will begin to blink when you have 1 minute left.
Very good. Thank you, Your Honor. May it please the Court, my name is Lester Firstenberger, and I'm the appellant. We're here on my appeal for a denial of due process based on a lack of notice in the underlying BVO proceeding.
Did you raise that? Did you raise that originally? When did you raise that for the first time?
On oral argument at the end of the appeal panel hearing.
Was that timely?
I believe so. The case law in both the Commonwealth and the United States Supreme Court are clear that to pass constitutional muster, all charges must be made with sufficient clarity and specificity that the attorney has notice of the charge and that he has responsibility to answer for, and that he has an opportunity to respond to that. Zeraderer and Rafala were the U.S. Supreme Court cases. In Abbott, this court in 2002 said that the right to fair notice of the charge and the right to be heard are among the rights afforded an attorney. If the Abbott standard still controls in the Commonwealth, the court has to make a detailed review of the petition and the hearing report because it is plain that neither I nor any reasonably intelligent or competent attorney could have known from the language of the petition that I was being charged with undermining priority of mortgage, the never noticed charge.
Good. Undermining what?
Undermining priority of mortgage. It's
a
a charge of first impression never articulated in American jurisprudence, which is one of the reasons I had no notice of it. Both the lower court and bar counsel hang their hat on the shift of theory of culpability language in Abbott as controlling here. The critical distinction ignored by both is that there is still an inviolate due process requirement that the charge be noticed to the respondent prior to the commencement of the proceeding. This is separate and apart from any issue relating to a shift in theory of liability. The elements of the charge must be pled with sufficient specificity and clarity so as not to offend our concepts of due process. That never happened in my case. Bar counsel pled a very specific petition for discipline that identified actions and omissions of me in April of 1999 as the gravamen of his noticed charges. I have no problem with that. I understand those charges. I defended myself on those charges. I had counsel, and I was completely exonerated of those charges. The question I appeal to you is, did the petition, as pled, give me fair and reasonable notice of the never noticed charge? And since I didn't have notice, did I have a fair opportunity to be heard on that?
Did you ask for any discovery that you were denied?
No. The hearing committee uses as the found actus reus the granting of subsequent mortgages as a strict liability standard. I'm an expert in mortgage and banking law. That's what I do for a living. I acted as counsel on mortgage transactions for over 20 years to the tune of $100 billion. I understand this area of the law. Had I known that the never noticed charge was something I was being held accountable for to answer to, I would have addressed the issue fully and described.
But you did know. I thought it was alleged that you had not filed. You had promised to, but yet had not filed the second mortgage given by your client.
That was a finding. It was hotly disputed. I never.
No, I understand, but you understood that was one of the critical fact things. You didn't file the second mortgage,
correct,
as you promised your client you would do, and that you then filed a second and third mortgage to others, which compromised your client's position. Why isn't that clear?
I didn't file the mortgages. They filed it. I granted.
You granted the mortgages.
Yes.
Knowing, according to the findings, that they would be superior to MLN's mortgage.
But that doesn't take into, consideration the doctrine of equitable subordination. The law of mortgage priority is twofold in the Commonwealth. There is the straight race notice, first to file, first in right, and then also the doctrine of equitable subordination. Had I known that...
Subrogation. Well, subordination, whatever.
Subordination.
Had I known that this was going to be a charge, I would have been able to put forth evidence that, what my father-in-law's understanding was. They knew of this mortgage. They knew that they were going to subrogate. My father subrogated to this. The reason my father-in-law didn't subrogate to it, I don't know, because...
He subrogated in a written agreement?
No, he simply allowed MLN to take the full amount in a settlement agreement.
Well, you're an expert in mortgage law.
Yes.
You knew, according to the board, found that MLN's mortgage had not been recorded, even though they wanted it recorded and you had said you would do it.
That was
Correct?
the finding. I never said that, but that's the finding.
Well, that's the finding, and you say there's
Yeah.
evidence to support it. So where is due process? They deal with this in the opinion. Where is due process violated in the manner in which you say it is?
Because they never gave me notice of the charge. The charge talks about actions and omissions in April of 1999. Looking at the petition in whole, there's no way you can read that petition and say, oh, gee, Attorney Firstenberger, we're also going to hold you liable and responsible to defend yourself on this claim that happened a year and a half after the gravamen of the petitioned discipline or charges. So
had you known a little bit more about this, you would have brought in your father and father-in-law?
absolutely, I would have defended and introduced evidence. The single justice says that the doctrine of equitable subordination is not applicable because there was no evidence of it. The reason there's no evidence of it, and it's the...
But it's irrelevant if you agreed to record that mortgage.
No, it's not, Your Honor. If you look specifically at the finding predicates itself on the fact, the hearing report, that regardless of whether there was an agreement, it's a strict liability standard, regardless of whether there was an agreement to record, it's that the fact that I simply granted mortgages is strict liability. That's not the case if you apply the doctrine of equitable subordination applicable to mortgage priority in the Commonwealth and across the whole country.
Okay.
The question I urge on review of the court is, isn't the fact that there was no evidence presented at the hearing by bar counsel or myself on the doctrine of equitable subordination or the never noticed charge, it is that fact. The fact that I had no notice of the charge, that I was unaware that I was responsible to defend myself on this.
But did you didn't raise this before the hearing panel, correct?
No, I didn't, because I didn't know of the charge.
And you didn't know that the hearing panel was going to find with respect to that?
Absolutely not. There's no way I could have. Take a look at the petition. There's no way that any reasonable person can read that and say, the charges of April 1999, the charges in paragraph 28 and 29, in addition to that, you're also going to be held responsible for actions a year and a half later, that while the fact was pled, just in a laundry list of facts, that I had granted the additional mortgages, it is not relevant to the complaint of the April 1999 actions.
But you would, isn't inherent in that or intrinsic in that you granted those mortgages and you would know that they would take priority because you hadn't done anything about the one before?
And again, it goes to my state of mind and scienter and intent. I would have introduced evidence as to my state of mind. I did not think I had the obligation to record those documents.
I thought you said you were an expert in
Yes,
mortgages.
but on that
I am.
point,
Then don't you know about recording mortgages?
I do, and it is, I assert to the court and represent to you that it is rare, if almost never happens, that the mortgagor files the mortgage.
the hearing committee didn't credit you on that, isn't that true?
No, it did not. But it's a relevant consideration because they don't predicate their finding on that. What they say is irrelevant, regardless of who was to record the mortgage. We're saying that it's strict liability. We're saying that because he granted these mortgages, he's violated the rules.
They s-
But the hearing, but it was also found that you told your employer that you would record the new mortgage.
Correct.
Okay, and then you didn't.
And that I didn't, but that was not what they predicated the finding of culpability on. They predicated that on a strict liability standard. They used the explicit words, regardless of who was to record. And the whole point is, Your Honor, that I didn't have notice of that this was the direction that they were going, or that this was in fact something I was responsible to answer to. Had I known, I would have presented evidence. I would have presented evidence in detail about the doctrine of equitable subordination, the law of priority in the Commonwealth. I would have had the opportunity to defend myself. I did not have the opportunity to defend myself. That's wrong. That shouldn't happen here. I was exonerated on the only, may I finish?
You may finish the sentence, sure.
I was exonerated on the only 2 charges in the petition. I would like to have that opportunity. Well, I'll leave it at that.
Thank you, Mr. Firstenberger. Mr. Warner?
May it please the Court, Robert Warner appearing on behalf of the Office of the Bar Council. The allegations in the petition for discipline made it clear that Mr. Firstenberger was going to be held accountable for granting subsequent mortgages to his father and his father-in-law, knowing
Where
that...
does it say that in paragraphs 28 and 29, in which you allege the violations, you don't say anything about that?
But if you go to those are the charging paragraphs, but if you go to the paragraphs in which allegations of misconduct are made, and those begin at paragraph, I believe it's paragraph 12. I just have a moment.
I understand that, but
What-
when you
what
come
pa-
down
what
to the
page
end,
are
you
you
say
on?
the respondent's false representations to Heffernan about the June 1990, that he would record the mortgage, and his intentional failure to record the mortgage violated professional responsibility 8.4c. Was he convicted of that? Was he found to have violated that provision in that fashion?
So he's found to have violated 8.4 by impairing his employer's priority by failing to record the mortgage and then giving mortgages to his father and father-in-law.
Isn't that very different from what you've charged him with?
I would suggest to the Court that it is not different, that the essence of what Mr. Firstenberger was being told he had done wrong was impairing the mortgage or impairing the priority position of his employer, who, as an accommodation to Mr. Firstenberger, had discharged his mortgage or had discharged its mortgage with the understanding that Mr. Firstenberger would then re-record the mortgage and place it in the same position that it was in prior to it agreeing to discharge its mortgage. And that when he didn't do that, and when he knew that he had not re-recorded that mortgage, and when he gave his father and his father-in-law the second and the third mortgages that he knew took priority over MLN's mortgage, that by doing that...
I understand that there's a finding that he undertook to record the mortgage, but that's rather unusual. It's usually the mortgagee. Believe me, the mortgagee is the one who's at risk here.
I understand, Your Honor, but there was different circumstances here. Here we had an employer-employee relationship between Mr. Firstenberger, who granted the mortgage, and MLN, his employer, who had given him the second mortgage. And that certainly the point that you make is accurate.
Gave him the loan. Didn't give him the mortgage. He gave the
No,
mortgage.
sorry. MLN gave him the loan, and then they secured the loan by a second mortgage on the property.
They trusted him. That's the point.
That's just it.
You know,
He
you're our lawyer. You record it. We trust you.
But let's get to the charges, which is what I think
Yeah, that's what I'm
certainly
saying.
being focused on. You charged that he made false representations to Heffernan. I take it that was not proved.
Well, I'm not sure if that's true, because the hearing committee did find that Mr. Firstenberger made a representation that he would record the mortgage and, in fact, didn't do it.
Right, but not that it was false, not that he didn't intend to.
They did not make a finding that that was false. That is correct.
In essence, finding that he intended to, he said he would, and he intended to, but he failed to do so.
And he took the mortgage with him intending to re-record the mortgage, but didn't do it. And then by failing to do that and subsequently granting mortgages, the essence of what he had done wrong is clearly pled in the petition. This court...
Show me where it's pled.
The facts are certainly, the factual predicate for
No, that's fine.
this
That's,
argument
that
is
tells,
pled, but
Yes, I understand. If I could just have a moment.
probably be, what, 16, 17, 18?
Well, actually, it begins with paragraph, I believe it begins with paragraph 13, or paragraph 12, I'm sorry. Paragraph 12 of the petition alleged that Mr. Firstenberger asked MLN, at the time his current employer, to discharge his second mortgage as an accommodation to him, and that he agreed to re-record that mortgage after he refinanced his first mortgage. Paragraph 13 of the petition alleged that the employer discharged, MLN discharged its mortgage, and that Mr. Firstenberger recorded the discharge with the registry. There's no question that that happened. In
right,
fact, Mr.
because he was
Firstenberger-
signed to get refinancing, okay?
Excuse me, Your Honor?
And he had told MLN that that's what he was going to do.
He had told MLN that he was going to he had asked MLN as an accommodation to him
Right.
to allow him to refinance his first mortgage, to discharge its mortgage. Now, the question came up in the hearing, and there's no finding made here, but as an expert in mortgages, the more common sense step would have been to have MLN simply subordinate its mortgage.
But that doesn't matter. They agreed to do this.
I understand.
They agreed
to do it. And so paragraph 13 says that they agreed to do it, and that as part of that agreement, Mr. Firstenberger took the discharge and then recorded it. Paragraph 15 alleges, and there's no question about the fact that after the refinance, the new first mortgage was recorded and it became, and it assumed first position. Paragraph 16 alleged that Mr. Firstenberger executed a second mortgage, a new second mortgage, and the hearing committee found that the discharge and the new second mortgage were executed at the same time, and that Mr. Firstenberger took the new second mortgage with him with the understanding that he was going to record it. Then paragraphs 17 and 18 allege that, and again, there's no question about this, that knowing that that mortgage had not been recorded, Mr. Firstenberger gave mortgages to his father and to his father-in-law that in fact took priority over the MLN, over the unrecorded MLN mortgage.
What
In
about
fact, took priority?
They took priority. They were,
What is this doctrine of equitable subrogation? If they had known that there was another mortgage out there, would they in fact have been given priority?
the problem with that argument is that it's not equitable subordination. It's equitable subrogation. And there is a distinction between subordination and subrogation. Subrogation means that you take the position of an already existing party. In the East Boston case that is cited by Mr. Firstenberger and by Bar Counsel, what happened there was that there was a first mortgage that was discharged by financing that was then filed with the registry. But what happened was the bank's lawyer failed to discover a mortgage on record. So the record title became this mortgage that had not been discovered, and then the bank's mortgage that had in fact paid off the first mortgage. And
What about your paragraph 29? Doesn't that suffice for what Mr. Firstenberger has been complaining about? 29 says the respondent's false representations to Heffernan on June 1, 1999, that he would record the mortgage given to MLN, and his intentional failure to record the mortgage violated such and such rules.
that's exactly...
Why doesn't that give him notice of what the charges are?
It does give him notice.
Well, first of all, the committee found he didn't make false representations, so that's a bit of a problem. At number 28, which is your second charging thing, the board found that he didn't do that.
Well,
So
if
what
you-
the board found is that he said he would file it and that he neglected to file it, not that he made false representations about it. And there's nothing further in that paragraph that says, thereby damaging the client's equity position or thereby causing harm to the client?
But if you look at the paragraph 29 charges that representations that Mr. Firstenberger made that he would record the MLN mortgage. And I think the finding is clear. The hearing committee found, the appeals court affirmed that that representation was made.
But it says false representation.
Well, if we put false aside for a moment, and if we look at the essence of what the petition is charging him,
It's charging him with a violation of 8.4c, which is engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation.
and that's what he was found to
Well, if
have
the
done.
board has found that he didn't make a misrepresentation.
But the board found he engaged in dishonesty, and that's the 8.c violation, and that's where the suspension was imposed on. So if
But
we
the
look,
dishonesty was giving the second and third mortgages.
the dishonesty was giving the second and third mortgage, knowing that the first mortgage had not been recorded. In fact, if you look at the appeal panel report added that day, made it a 6-month and a day suspension because of Mr. Firstenberger's rather cavalier approach that I didn't have any responsibility to record anything, even though I knew when I granted these new mortgages that the MLN mortgage had not been recorded.
Did Mr. Firstenberger apply to reopen the hearing at any point after?
He did, and that was denied. If there are any other questions, thank you.
Thank you, Mr. Warner.
All rise.